Okay, well, good afternoon, everyone. Welcome to everyone who is here at the Contemporary Art Museum of Houston. Welcome to everyone on the internet, wherever you may be. This is going to be an art law CLE. I am Derek Fincham. I'm a professor at South Texas College of Law, Houston. The college pays me to teach legal research and writing, but I would teach art law and copyright law for free. Please don't tell the dean that. So art law, copyright law, the law dealing with monuments and cultural heritage, the stuff that really matters in my view is the subject of what I write about. And so today's CLE, if we could pop over to the next slide, is going to bring together a whole bunch of disparate things. Here is the question: what does a selfie taken by a monkey, the musician Prince, Andy Warhol, graffiti, the Union Pacific Bridge just north of downtown Houston, I think it's north of downtown, kind of, the Be Someone Bridge, as us Houstonians know, and public social commentary art have in common? Well, they are all the subject of today's CLE, and I will try to bring them all together if I can, with plenty of pictures, and hopefully try to bring in a lot of Houston stuff if I can. So if we could pop over to the next slide. The writer Austin Kleon, who is a great thinker about creativity and the creative process, he likens a copyright dispute, a copyright case, to an Elmore Leonard novel. So think here, Raylan Givens on Justified. Think about Jackie Brown, the Quentin Tarantino movie. In any Elmore Leonard novel, there's a big bag of money. Everybody's trying to get their hands on it. The smaller the turf, the bigger the dispute. And as it becomes harder and harder to make a living, as the collective bag of money for musicians and other artists shrinks and shrinks, there will be a need for plenty of attorneys like y'all to help resolve the disputes over whatever is up for grabs. Because the only surefire real winners in any copyright case, in my view, are the lawyers. Rarely has anything to do with the art. It's rarely about the image itself or the art. Every artist knows that art comes from art. It's only the honest ones admit it. We all, if you're an artist, you steal from every other artist. In other words, you stand on the shoulders of other artists. But we live in a legal system that sometimes leads musicians to being advised not to acknowledge any influence, to hide the truth, so we may be stuck navigating what we think is best for the art and what is the law. If we could go to the next slide, please. This is a selfie taken by this monkey. This is on display right across the street in the Nancy and Rich Kinder Building at the Museum of Fine Arts in Houston, and made for a surprisingly lengthy Ninth Circuit opinion in 2018. Because this monkey, PETA sued on behalf of this monkey for copyright. How can a monkey sue for copyright? Can monkeys even own a copyright? So in 2018, the Ninth Circuit threw out a copyright lawsuit brought by PETA on behalf of this Sulawesi crested macaque. I believe I have a reader's pronunciation of that animal, but that's my best try. The close-up photo of this monkey grinning broadly at the camera went viral on the internet back in 2011. And it was a wildlife photographer by the name of David Slater. He left his camera on the jungle floor, was maybe doing something. The monkey real quick grabbed the camera and took what I think is probably one of the best selfies in the history of the world. Mine are never that good. And this is just a perfect smile, centered in everything, super cool. PETA brought a suit, People for the Ethical Treatment of Animals. They brought a suit against the photographer and a book company that was publishing some of those images in 2015. And they claimed that he had infringed the monkey's copyright by releasing Wildlife Personalities, the self-published book of photos. And the Ninth Circuit concluded that the Copyright Act does not clearly state that animals can sue. Dad joke warning on the way. In fact, with its numerous references to legitimate children and widows and widowers, probably only humans who can get copyright. So under the precedent, monkey can see, but monkey can't sue. In a long, rambling footnote, the court went after PETA, the Ninth Circuit did, with a vengeance. On one footnote, which I'll read to you here, the court even wrote, puzzlingly, while representing to the world that animals are not ours to eat or wear or experiment on, use for entertainment or abuse in any other way, PETA seems to employ Naruto, the name of the monkey here, as an unwitting pawn in its ideological goals. And in fact, the Ninth Circuit thought that previous case law had not gone far enough in borrowing these kind of PETA-style lawsuits. A previous case had concluded that PETA brought on behalf of whales, porpoises, and dolphins against the Bush administration for various naval activities didn't go far enough. And so this monkey selfie case went even further. The panel said it was bound by previous precedent, but asked for the Ninth Circuit en banc or even the Supreme Court to keep animals out of court in this way. So the 20-page concurrence, the opinion probably should have been 3 pages long, but there was a 20-page concurrence which just hammered PETA because originally, of course, PETA brought the lawsuit as a next friend, where for example, someone like a very young child or someone who might be too incompetent to sue might bring a claim. And so that's the legal grounds on which PETA brought the suit. What to think about the monkey selfie case? Well, it's a beautiful image, but probably the monkey doesn't need copyright to make beautiful images, I guess. Maybe nobody actually even owned the picture. Some things aren't owned, and maybe that's okay, because most of our culture and history and knowledge isn't really owned by anyone at all. It's available for all to use in the vibrant and ever-expanding public domain. The domain is populated by formerly copyrighted material that was never copyrightable in the first place. So we might think of things in the public domain as literature and art and music and movies for which the copyright term has lapsed or expired. Or sometimes a rights holder will donate their works to the public domain. Under the original US copyright law, each generation was largely free to use the copyrighted material of previous generations because terms were much shorter, and so was the scope of what could be copyrighted. But terms, as copyrights have grown more and more valuable, and things like the mouse, the Mickey Mouse, and other things have encouraged members of Congress to extend the copyright term. Terms have grown longer and longer. And we didn't have anything entering the public domain until just a couple of years ago. Material from 1923 onward finally started entering the public domain each year. We will see whether or not, when the mouse runs out of its copyright term in a year or so, whether or not that term gets further extended, which will be fascinating to watch. There's another set of ideas that are not copyrightable that are in the public domain. Knowledge, truth, conceptions, ideas, maybe colors, as we were discussing, maybe those things cannot be copyrightable. As Judge Louis Brandeis said, the general rule of law is that the noblest of human productions, knowledge, truths ascertained, conceptions, and ideas, become, after voluntary communication to others, free as the air to common use. So those of us who are in, who might be called copyright maximalists, I wouldn't put myself in that camp, but copyright maximalists kind of think the public domain's kind of lame. It's not the best thing ever. It's just a space that creative works fall into eventually, once their financial value has been thoroughly exploited. But in fact, lots of very valuable works occupy the public domain, and maybe even more there than in the private domain. And it's every creator throughout human history except for these last, the last copyright term. So their work in the public domain itself reminds us that the copyright monopoly, which is a very powerful right owned by copyright holders, and the assumptions it embodies about how to spur creativity, only represent a limited exception to the general rule. Most production of knowledge and culture has always taken place within the public domain, and chipping away at the domain will inhibit rather than encourage, perhaps, new creativity. And I think I neglected to mention, if there are any questions in the room here at the museum, or if there are any questions on the internet, wherever you may be, please put those in the chat or raise a hand and we can respond to those. I can respond to those. So if we could pop over to the next slide. It's a very boring image of a fair use logo. So the copyright monopoly is very broad. And so apparently copyright is just for humans, according to the Ninth Circuit now. But what when we take too much? What happens if that monopoly takes too much of the rights? Fair use is the remedy for us. It helps balance the overload of rights which can sometimes flow to copyright holders. So because this is a CLE, I'll give you a crash course in fair use. Fair use is a flexible standard that limits the scope of copyright protection and renders certain actions relating to copyrighted works non-infringing. It's a fair use, despite the fact that it might brush up against the monopoly that a copyright holder might have. Some activities that courts have regarded as fair use that may have otherwise been infringing include quoting a significant portion of a work for the purpose of criticism, illustration, comment, or clarification, parodying a work perhaps, and copying part of a work in the course of classroom activities. So fair use is a requirement. It's necessary for us because licensing and other private ordering mechanisms don't provide a solution for cases involving high transaction costs or strategic holdout or accidental copying. My students, of course, would never do any accidental copying in their legal writing. The fair use doctrine is particularly important in situations where the costs of obtaining permission may outweigh the benefits of use. And it plays a really helpful mediating role. The Supreme Court last took up fair use in a big way in a case, Campbell versus Acuff Rose from 1994. This is one of my favorite cases the Supreme Court has ever decided. It involved Roy Orbison's song Pretty Woman, and Two Live Crew parodied Pretty Woman in a very silly manner. And Justice Breyer, writing for the majority, held that it was a parody and was transformative and thus was fair use. So the closer you can get to transforming something, the more likely you're going to be able to be considered a fair user. The fair use doctrine does a lot of work in the modern American copyright system. In many ways, fair use functions as an inherent limitation on copyright, similar to the idea-expression dichotomy, which we talk about in copyright law, or the requirement of substantial similarity. But in other respects, the fair use doctrine produces a set of rules through case law that look more like true limits and exceptions. So we're going to extend, forego an extended theoretical discussion of fair use and jump into a discussion of a recent case decided this year. These are the fair use factors. It's a factor test, which always makes it, as an attorney, very difficult to apply. Purpose and character of the use are things a court will consider. The nature of the copyrighted work, the amount and substantiality of the use, the effect of the use on the market, are all things that a court is meant to consider in a fair use dispute. And that was what was considered in this case, involving a photograph taken by Ms. Goldsmith of Prince in the early 80s. I think if you go one more slide, we can see. So on the left here, you can see the photograph that she took of Prince. On the right, you can see Andy Warhol's appropriation of that photograph into a work of art. So the Second Circuit held that Andy Warhol's use of this photograph, the Goldsmith photograph, to create 15 new unauthorized silkscreen and pencil artworks was not fair use and violated her copyright. And the decision has big implications for the legacy of Andy Warhol's art. We all know who Andy Warhol is. And we'll think about him a little bit more in a minute. And it also has a big implication for other artists who appropriate, who take photographs and change it around. So the Second Circuit's opinion gives some really useful, important clarification for how the Copyright Act's fair use test is applied to visual works of art. For me, I have a hard time figuring out what is and isn't fair use. Maybe y'all can help me figure out if I'm right or wrong by the end of today. So if we could go to the next slide. The pop philosopher Alain de Botton helps remind us why Andy Warhol was such a momentous figure in 20th century art. He created for us a really cool and helpful view of two of the foundational forces in modern life, commerce and celebrity. He spent most of his life as a celebrity, but he was also really interested in business. He was a very successful commercial artist. And his art gives us four really important ways of looking at the world. He says we spend way too much time wanting something better, wanting something extraordinary, and it's normal to feel that exciting things are not where we are. He wants to fix this for us by getting us to really look again at the things in our everyday life. If you could click to the next slide. This is, of course, what we probably think of when we think of Andy Warhol and his soup cans. By putting soup cans on the wall, we're able to see their beauty, their labels, the perfect fit in a Campbell soup can between its form and function. He also cultivated what he called superstars. He said their power is being that they can distribute glamour to everyone and prestige to everyone. And he thought that glamour needed to be redistributed so that society might work a little bit better. For example, he suggested You can go to the next slide. It's a little silly. This is Maurizio Catalan's gold toilet. The connection is this. Andy Warhol suggested that the president, it was President Ford at the time, could use his status to shift perceptions. Andy Warhol said, and I can't do an Andy Warhol accent or impersonation, so I won't try. But Andy Warhol said, I've always thought that the president could do so much here to help change images. If the president would go into a public bathroom in the Capitol and have the TV cameras film him cleaning the toilets and saying, why not? Somebody's got to do it. Then that would do so much for the morale of the people who do the wonderful job of keeping the toilets clean. I mean, it is a wonderful thing that they are doing. And I guess we all love a good clean toilet. Of course, Andy Warhol is right. You go to the next slide. So Andy Warhol didn't call his workplace a studio, as artists had done since the glorification of the artist as lone genius with Giorgio Vasari and his Lives of the Artists. Instead, he called it the factory. Art may seem like it's not very close to a factory, but Warhol argued that business and art belong together. He said, good business is the best art. He said, we can organize ourselves to produce things more reliably and cheaply. He compared Coca-Cola to art. He said, you can go anywhere in the world and have a Coke, and it's pretty much the same thing, and it's pretty much delicious. Art, he said, is not quite able to live up to this standard. It's not yet become widely distributed. Artists make a few things, but only a few people get to own them. One day after learning Picasso made 4,000 works of art during his lifetime, here's the man himself, Pablo Picasso, Warhol set out to create 4,000 works of art in a day. It ultimately took him a month to make 500, but that's still a lot. And the lesson we might take is that mass production needs to apply beyond making high and conceptual art. We need to rely on the branding, commodifying powers, and business to spread the good things in life. What are the good things in life? I guess we all get to decide. Career advice, beautiful architecture, yummy pasta, good legal advice, whatever else. So much art has very little impact, but not Warhol's. He mastered drawing, painting, film directing, sculpture, theater. He managed a band called the Velvet Underground. He made 60 films. He was so successful because he was a populist. He was unafraid to reach people where they were. His invitation is to follow in his footsteps. He died at the tail end of the 80s at a tragically young age of 58, but he did help change the world in a mass populist way through art. One of the ways his legacy lives on is through the Andy Warhol Foundation, which manages the artist's estate and safeguards his artistic reputation. As the rules of appropriation art have changed since his passing, his art, while still populist, has shifted in the background, and its recognition accorded to it by courts. So if we could click through to the next slide, perhaps. Here's Chairman Mao, which got the Warhol treatment. And then if we could do one more. So here's the photograph that was at issue in the Andy Warhol case. So the original copyright holder is a woman named Lynn Goldsmith. She's a music photographer. She would take pictures of musicians. So you can find her photographs at record stores, and she does well for herself, but she doesn't really change. It's just the photograph, it's not the Warhol treatment. Her method was to get the musicians into her studio, get them comfortable, play some of their music, and try to get them to just exist. And she could take a photograph of them in a way that you could perceive them and their music in a different way. She took this photograph of Prince in 1981. And in 1984, Goldsmith's photography studio licensed the Prince photograph to Vanity Fair magazine for use as an artist's reference for an illustration that would be published twice in the magazine, with an attribution back to Goldsmith. No other use was authorized. And Goldsmith alleged that without her knowledge, the Vanity Fair artist was the man himself, was Warhol, and that in addition to creating a work for the magazine, Warhol also used her photograph to create 15 other silkscreen prints and pencil drawings, which depicted Prince. So according to Goldsmith, she didn't learn of the Prince series until 2016. That was when we had the untimely passing of the musician Prince. And the magazine published some of the images in a posthumous tribute to Prince. When she saw the tribute publication, Goldsmith contacted the Warhol Foundation, the rights holder for the for Warhol's copyright. but the parties weren't able to privately resolve their dispute. Goldsmith allegedly wanted 7 figures for the right to license this photograph. So in 2017, the Warhol Foundation raced to court first and brought suit. And they brought suit in the Second Circuit. The Second Circuit has well-developed fair use jurisprudence. If Goldsmith were to bring suit, she perhaps would have sued in the 10th Circuit, which is where she lives in Colorado. Maybe does not have quite as developed a fair use set of jurisprudence. So it's the Warhol Foundation who sued, and they maybe ultimately rued the day they decided to do that. The Warhol Foundation asked for a declaratory judgment that the print series works are non-infringing, and in the alternative, a finding that the print series is a fair use of the Goldsmith photograph. Goldsmith and her studio countersued, alleging for copyright infringement, and asked the court to, among other things, bar the foundation from reproducing, modifying, preparing derivative works from selling, offering to sell, publishing, displaying, or claiming copyright ownership of the print series or any of the images in it. And the key issues in the case were, of course, whether Warhol's print series and the licensing and republication infringes Goldsmith's original copyright, and if the print series qualifies as a fair use to evade copyright infringement liability. In 2019, District Court for the Southern District of New York granted summary judgment in favor of the Warhol Foundation, skipping right past the copyright infringement issue and finding that the print series was fair, and dismissed Goldsmith's copyright infringement counterclaim on the same basis. And the district court's decision turned largely on its finding that the print series is transformative. And I think if we go to the next slide, yeah, you can judge for yourself whether Warhol transformed the photograph or not, whether you agree with the district court or whether you ultimately agree with the decision of the Second Circuit. Because the Second Circuit reversed, and it held that there was not a fair use, that there was not a transformation, and that transformativeness gets too much credit, gets too much sway in the fair use analysis. The court acknowledged its recent fair use copyright decisions could be misread to broadly hold that a second work is necessarily transformative as a matter of law. If it's got a different character, a new expression, or employs some kind of new aesthetics from the original work. The court explained that this broad reading is wrong. The Second Circuit conceded that prior fair use cases involving works of art had reached different and arguably inconsistent conclusions on the question of transformativeness. And if you go back and read those cases, they involve Jeff Koons and Richard Prince. And really, I think what has happened is the artists have gotten better at giving depositions, at convincing courts that they are transforming. They're getting better at selling their art, in other words. And perhaps it was a difficult haul for the Warhol Foundation in this case, because they didn't have Andy Warhol to give a deposition. If they did, he might have been the star of the room, and he might have had a different impact on the fact finding that took place. So the court assessed the four fair use factors and reversed the lower court. Factor one was the big one, the purpose or character of the use. Here the Second Circuit said the district court made a mistake in finding that there was transformation here, and that factor one favored fair use. The different Warhol-esque aesthetic of the print series is irrelevant, the Second Circuit said. I think that's arguable. I think there's a big difference here. I'd probably agree with the Warhol side. Also, the print series retained the essential elements of Goldsmith's photograph without significant additions or alterations. And the lower court improperly based its decision on a stated or perceived intent of Warhol rather than on the reasonable perception of the print series. Factor two, the Second Circuit said the lower court made a mistake by relying on its transformativeness. And instead, the Second Circuit, a finding under this factor is just not all that important. It should be given less weight. Factor three, the amount and substantiality of the use, the lower court incorrectly found that this factor favored fair use because despite cropping and maybe flattening the image, here we get just the face, right, of Prince. Warhol quantitatively and qualitatively, the Second Circuit held, borrowed the essence of the Goldsmith photo. Factor 4 then was the effect of the use on the market for the original. And here this is an interesting issue because Goldsmith had never tried to license the print series, had never licensed any other photograph before. She had a, kind of a direct sales model. And so Vanity Fair has lots of Warhol-esque things on its cover. And so the market impact probably shouldn't have made much of a difference, but the Second Circuit said that it did. So what are the takeaways? I'm as confused as ever about what is and is not fair use. Maybe that's just me. Fair use is unpredictable. We also have some class distinctions happening here with these photographers and the artists. So a lot of these photographers are, working class folks. Basically, they're photographers. They are not mega millionaires, of course. And so when you compare them to a Warhol or a Jeff Koons or Richard Prince, that seems to kind of be at play here under the surface of some of what the courts are looking at. Why not just pay for these photos? Why not just pay for a license? It's hard now, after this case, I think, for visual artists to appropriate content without licenses to defeat infringement claims with fair use defenses, especially in the Second Circuit. Obtaining a license or just borrowing works in the public domain would be a much safer course of action. So maybe we'll see more artists drawing from the public domain. Artists who use appropriated content might be more likely to gain fair use protection if they don't just take from one photo. So maybe Warhol's mistake here was he needed some other photos of prints or different sources, perhaps. Or maybe remove all the protectable elements from the borrowed work in the new work. So try to figure out what is the protectable essence, the copyrightable essence of what Goldsmith used in the photograph. Let's take that out and but if you do that, I don't know how much of prints you actually have left. The other argument that I found interesting that the Warhol Foundation used is that the picture here, although Goldsmith posed him, picked the composition and the lighting and the focus, it's Prince. He's the star. And so it's really Prince whose essence is coming through, I think. So I guess I would have ruled for the Warhol Foundation in the case. So if you've got a new artwork, if it doesn't clearly comment on or relate back to the original work, if it's not doing a parody like Two Live Crew did, if it's not criticizing in some way, if it's not adding something really overt, then something more than just an artistic intent or the assertion of a different or higher purpose is going to be needed. Okay, so that's fair use in a nutshell. And let's shift gears and think about the art on the street, following through from our art law walking tour. And here, I'm going to touch real briefly on the 5 Pointz litigation. So graffiti is the art that we see on buildings. It's one of the words for it. Sometimes it's called street art. Sometimes it's done with the permission of the building owner. Sometimes it is trespassory or done without the permission of the building owner. As Justice Oliver Wendell Holmes said, when looking at the legality and how the law applies, if we love street art or we hate street art, we need to take that out of our calculation. Judges, according to him, cannot be connoisseurs. And so the 5 Pointz litigation invokes something called the Visual Artists' Rights Act. In 1990, Congress brought the United States into line with the Berne Convention for the Protection of Literary and Artistic Works. This is the international collective. I almost describe it as the United Nations of nations which want to pool their resources and harmonize their laws, which regulate creativity, copyright, and cultural production. The Visual Artists' Rights Act, I'm afraid, does not have the benefit of great drafting. The Italians, when they make their laws, they strive to do what they call a bella legge, or a beautiful law. That is not what our members of Congress were doing when they created the Visual Artists' Rights Act. It is a difficult set of principles to work through. But what moral rights is trying to do is protect the spirit and the personality that artists put into their work. So work should be protected from change or from destruction. And so the Visual Artists' Rights Act was Congress saying, here's the rules that we're going to use to put our values in line with the Berne Convention. These rights are limited only to fine art, paintings, sculptures, drawings, prints, or still photographs, things that have been produced for exhibition and are only single copies or limited editions. And so the moral rights structure under the Visual Artists' Rights Act gives artists a non-destruction clause. People cannot destroy your art if it's a work of recognized stature, but an artist must show that the art community or society in general view the work as possessing each such stature. It doesn't have to rise to the level of a Warhol or Picasso, but it must have recognized stature. Congress did not give us the benefit of telling us how we would determine recognized stature, so courts have done their best. There's also this idea of intentional distortion, mutilation, or modification of a work of art, which is prohibited. So the story of 5 Pointz, this is a now demolished building. In the 1990s, a man named Jared Wolkoff began renting some warehouse space to street artists. And over time, the warehouses became an acclaimed location for street art. One of the subway trains in New York would pass on a lifted platform around 5 Pointz. And so if you look on YouTube, there's some wonderful just YouTube videos, phone videos that people on the subway on their way home or to work have taken of all the art around the building. So it's all sides of the building. The warehouse eventually gained the name 5 Pointz. And as the artists moved in, as often happens, the neighborhood became cooler and hipper, and the property became more and more valuable. In 2011, Wolkoff decided it was time to knock down the warehouse and develop a high-rise residential tower on the spot. His intent was to make a luxury, high-rise and have elements of street art or graffiti in the lobby and around the building. The street artist community protested the action, but because the Visual Artists' Rights Act isn't really widely known in the arts community, it was not an easy fix for these artists to come in and prevent what Wolkoff was doing. And in 2013, Wolkoff made a very big and very expensive mistake for himself. And rather than wait the required period to allow the artists to protect and preserve 10 months only the art in whatever way that was possible, he whitewashed the building in the middle of the night and then demolished it. And so the artists whose work adorned the walls brought suit under the Visual Artists' Rights Act for reparations for the artwork's destruction. Among the various defenses, Wolkoff argued that graffiti could not rise to the recognized stature required for protection by VARA. A jury disagreed and awarded the artists $6.7 million. And it was the first time that graffiti or aerosol art had been given that protection under federal law, and it may have far-reaching implications for other graffiti murals across the country, even here, not far from us in Houston, which I'll talk about in a moment. This might be a growing practice area, and if you'd like the deliverer of the CLE to help you on a pro bono basis to write some briefs or help you research the issue, I would be delighted to do that. 45 works, I think here for $150,000 per work. So $6.75 million. This was appealed to the Second Circuit. It was upheld. There was a rigid kind of a vetting process that Maris won, otherwise known as, his real name's Cohen, but his like street art name was Maris One. He's a distinguished street artist, and so he had a very particular vetting process. So you couldn't just, as anybody off the street, come in and put your art on the building. You had to kind of earn your way in. And so it's a very expensive, very, very expensive mistake for the developer. If we can go to the next slide, the reason that was an exciting case for yours truly was because it has a lot of implications for street art in the rest of the country. This is a George Floyd mural here in the East End. I think this is at the Houston Graffiti Park. I think this one, it was created by Daniel Nguilu, I believe. It was defaced. It's been, this one, particular one, I believe has been defaced at least 3 times. It's a George Floyd mural memorializing the man's life, his untimely passing, his killing. And it's obviously a beautiful image. I think if we can go to the next slide, Daniel Nguilu fixes it. he repairs it. He puts it back as it was each time that it's been defaced. But whoever's doing that is violating his moral rights. They're hurting his personal rights as an artist and potentially opening themselves up to $75,000 or $150,000 in statutory damages. And so maybe some of these street artists need to put some cameras on their street art and try to figure out who these folks are who are defacing these murals. When we talk about art that's on the street, art that's in public, everyone has an opinion on it. It's for everyone to see and for everyone to kind of think through and think about it. We can go to the next slide. This, of course, is the Be Someone Bridge. I don't know if it's Be Someone right now. Hopefully it will revert back to being Be Someone. This is trespassory art. So this bridge belongs to the railroad. And they just look the other way and allow these artists to create on this steel canvas. You can go to the next slide. This is a notorious work of art called Tilted Arc. It's a work of art by Richard Serra. This is a plaza in New York City from about 1980 to 1989. This tilted arc occupied the space in New York City, the Federal Plaza here. It was paid for by the General Services Commission. I believe that's the right name, essentially the US federal government. Artists loved it, art critics loved it. It was a way to occupy the space, view the space differently, take in the space. Commuters and people who worked in the building hated it because it meant they'd be late for work. You couldn't go right through the plaza. You had to go around. Maybe that was the artist's idea. Before the Visual Artists' Rights Act, Richard Serra brought suit against the federal government, requesting that they not move this, that it was a violation of his First Amendment rights, but he was unsuccessful. And so art that occupies the public space can oftentimes be contested. So if we could go to the next slide, this is my image, so it's not quite great. But it is a beautiful work of art. So this is over here in Montrose. This is the broken obelisk at the Menil. An art historian by the name of Amanda Moberly wrote a terrific history of the broken obelisk and the struggle that the de Menils had in finding a place for it in Houston. It currently occupies the plaza opposite the Rothko Chapel. But we start the story of this obelisk back in 1967. The city became one of 2 cities to be awarded a matching grant for public sculpture as part of a new federal arts program. The city had, prior to the deadline in 1969, the city hadn't quite raised the matching funds or selected a site for a sculpture. And so the Houston Municipal Art Commission, which had been charged with administering the grant, turned to John and Dominique de Menil for help. Now, at first, the couple did not offer matching funds, but instead wanted to bring Claus Oldenburg to Houston so he could sketch the ideas that could be used for fundraising. And in March of 1969, the Menils announced that they would give the sculpture to the city and give matching funds for the grant on 3 conditions: that Barnett Newman, who created this work, be the sculptor, that his work Broken Obelisk be the sculpture, and that a nationally recognized landscape architect such as Kevin Roach or Louis Kahn design the site. And they wanted it originally to be in Market Square, right downtown. I think if we could click through to the next slide. Yeah, so this is Market Square Park. This is as it existed in 1905. This is not the best image, but it's the best I got. So one of Houston City Halls was originally here in Market Square Park. This is a statue of Dick Dowling. Richard Dowling, he was a Confederate soldier. He, I think from what I can understand, my historical research is he led Confederate forces and prevented Union forces from coming up, I think it's the Sabine Pass. And so he was credited by particularly Irish Catholics in Houston as preventing a Union occupation of the city of Houston. And for some, they thought that was quote unquote saving the city. The Menils wanted to put Broken Obelisk here and have Dick Dowling's statue. It was moved, I think in the 50s, over to Hermann Park. Broken Obelisk was installed in 1971. It's the 50th anniversary of that this year, here, of course, in 2021. The Dowling statue was removed last year. in the wake of the Black Lives Matter protests. So if you go to the next slide, this is John and Dominique de Menil. There is some really exciting, interesting back and forth in history of how the Menils worked with the city of Houston, how they worked with the city council, how they worked with Barnett Newman and others to find a spot for the broken obelisk. So in the 60s, Houston was embracing a civic image based on an emerging industry that would be the space industry. With NASA arriving, Houston was fast becoming Space City, USA. Arts advocates in the city, of whom John and Dominique de Menil are one, and of course they were, I think, influential in founding the organization that would become the Contemporary Arts Museum of Houston, in which we are standing today or sitting today. Site selection was a big problem to find a spot for broken obelisk. The Houston Arts Commission, Municipal Arts Commission, initially proposed a place called Root Square, which is just on the southeastern fringe of downtown, that had been donated to the city in 1923. The choice, as the chairman Roger Stevens put it, was trying to salvage a section of the city that was, quote, going downhill, or finding the best place possible in the city from an artistic point of view. And so other voices, including landscape architects, spoke in favor of viewing the sculpture as a generative force for urban renewal. And in changing the site, the Houston Monuments and Arts Commission didn't abandon urban renewal, but instead simply put sculpture in a renewal area. Let me talk for a moment about John and Dominique de Menil. They are any really terrific arts institution in Houston, probably owes at least part of its debt to the de Menils, whether that's the Museum of Fine Arts in Houston, this institution, the Menil itself, Art Museum on the Rice campus, pretty much anything, St. Thomas. The Menils were prominent Houston arts patrons, to put it lightly. They had been for 25 years by the 1960s. In 1956, they commissioned a master plan for the University of St. Thomas, which is why that perhaps is such a beautiful campus to walk through over in Montrose. They had originally planned to do something with that university's art department, but they decided not to proceed and initiated their plan for a chapel on property that they owned in the Montrose neighborhood. So Dominique de Menil visited Mark Rothko. So the Rothko Chapel, that's what's on the Menil campus. Dominique de Menil visited Rothko in the spring of 1964 and asked him to create a cycle of paintings for a chapel. And the de Menils engaged Johnson as an architect, who was replaced by a couple of others, Howard Barnstone and then Eugene Aubrey. The facility is currently freshly renovated. It is gorgeous. It is really a nice space. I tell my students, go there before finals. It'll clear your head, lower the blood pressure. You'll do better on exams. I don't know if it does the same when you're getting ready to go to court or getting ready to do a negotiation, but it can't hurt. I always feel better after leaving the Rothko Chapel. But the Menils offered broken obelisk to the city of Houston, and they wanted broken obelisk to be somewhere in a prominent part of the city, and they had difficulty working with city leaders to find the right spot. I think if we can go to the next slide. This is Houston as it existed in 1964, an overview of the city. If we could click again one more time. What ended up happening is what is now Tranquility Park was seen as a good place to put broken obelisk. Businessmen and civic officials said, okay, we'll put this here, but just the week before, there was the moon landing happened basically in 1969, and the city council, the mayor of the city, both agreed, well, we need to commemorate that moon landing somehow. And so Tranquility Park exists right there. Here's a picture of Tranquility Park. Which meant, though, that broken obelisk was rejected by the city council. And so if we could click one more time. So this is what broken obelisk looks like. At the time, the Menils wanted broken obelisk to be dedicated to Dr. Martin Luther King Jr., who had been murdered only a short time earlier. And they wanted that to be displayed either in Market Square Park, replacing the Dowling Confederate statue, or right on the doorstep of Houston City Hall. But the Houston City Council was not ready to do that at the time. And so the Vanilles put broken obelisk here in front of the Rothko Chapel, the non-denominational chapel. And so whatever you think about broken obelisk, I'd be interested to hear, perhaps after the talk, but for me, it is one of the most beautiful pieces of sculpture. It calls to mind the monumental sculpture of ancient Egypt and the obelisks. Think of the Washington Monument, but it's turned on its head. The last shall become first, the first shall become last. So whoever's at the top, it's a great equalizing sculpture, and it's a very diverse kind of a different pinnacle at the top that speaks to something different being built than just strong government or a strong pharaoh or a strong federal government. After the announcement that broken obelisk was going to be rejected by the Houston City Council, the artist, the sculptor, Barnett Newman, wrote a letter of thanks to the Vanilles, and he said, "Here it is. May I now express my appreciation and my admiration for your great courage. When you honored your gift by dedicating it to the memory of Martin Luther King, you also honored my work by rescuing it from the Philistines who would have destroyed it as a work of art and made it a political thing. I hope that my sculpture goes beyond only memorial implications. It is concerned with life, and I hope that I have transformed its tragic content into a glimpse of the sublime." So that dedication spared Newman's sculpture further debate by an unsympathetic Houston City Council, exposed the council's politics, and of course it's paradoxical that in order to save broken obelisk as a work of art, the Vanilles made it into a monument and assigning broken obelisk a specific meaning. So they attached a meaning to it, limited the sculpture's interpretation, and made it ineligible for federal funding. But at the same time, it sharpened the message of the inverted obelisk, which had made its dedication as a memorial seem appropriate to the Vanilles in the first place. And like I said, it's fitting that on the 50th anniversary of broken obelisk's dedication here in 2021, the Dowling Monument has been taken down. It's been removed from Hermann Park over here. This is where it used to be. And I think if we go to the next slide, you can see it being carted off. It was not destroyed. I believe it's preserved somewhere at a special park. So it's somewhere, it's just not on public display in pride of place in Hermann Park. And it was Houston's first public monument. So if Houston's first public monument did indeed play a role in the Vanilles' decision to dedicate broken obelisk to Dr. King, then one might ask what new public sculpture their statement will inspire today. And as I tell my art law students, a city, a government, a people preserve and protect the art that they value. And sometimes that struggle becomes too contested and procedural, and political conflict can grind the art down. In that sense, maybe we can understand why somebody just climbs a railroad bridge and decides to paint "Be Someone" on the Union Pacific Bridge. I think there's one more image here, of the broken obelisk. So with that, I've tried to take us from a monkey selfie to the Dowling statue and the broken obelisk. I don't know if there are any questions at all. Otherwise, we could maybe take a nice long awkward pause and perhaps conclude, but that's all I have. If there are any questions in the room, if not, that's okay. Thank you for your time. Thank you for your attention.
Thank you. That's great.
Thank you all.